How many hours can an employer require their employees to work in a day? Do interstate migrant workers get special protections? Who should take the responsibility to make sure that the workplace is not hazardous? These questions and others like it are answered by the Code on Occupational Safety, Health and Working Conditions that was passed in Parliament in 2020. The code replaces 13 existing acts. Hi, my name is Itika, and today we're looking at the key provisions of the Code on Occupational Safety, Health and Working Conditions. The code fixes the maximum number of working hours in a day to 8 hours. Further, workers must get 1 day off in a week and 1 day's leave for every 20 days worked. The code also has special provisions for certain groups of workers like journalists and sales promotion employees. The code prescribes a list of duties for employers. One of these mandates the employers to issue an appointment letter to all their workers. As per one statistic, 70% of salaried employees in the non-agricultural sector did not have a written contract. The code requires employers to provide a workplace that is free from hazards that could cause injury or diseases. To do this, the government may further require construction sites, mines, or factories of a certain size to set up safety committees comprising of both the employer and the employees. The code also makes changes in some definitions that may change who is covered under the Act. As per the 1948 Factories Act, a factory is defined as any premises where manufacturing takes place and has 10 workers on its payroll if the process is carried out with power and 20 without power. The 2020 code increases the threshold to 20 workers for premises where the manufacturing is carried out using power and 40 for premises where it is carried out without using power.
The 1970 Contract Labor Act prohibits and regulates contract labor. Today, it applies to establishments or contractors employing 20 or more contract workers and also allows the state or the central government to notify a lower threshold. The code changes this and specifies that it will now apply to establishments or contractors employing 50 or more workers. An interstate migrant worker, as per the 1979 Act, is anyone who is recruited by or through a contractor in one state for employment in another state. This may be with or without knowledge of the principal employer. The code specifies that only those people earning a maximum of rupees 18,000 per month will be considered as interstate migrants. The central government can increase this amount.
Another change is that the code does not provide a judicial mechanism for hearing disputes under it. Under the current health and safety laws, claims related to the rights of workers can be heard by labor courts and tribunals. The code bars civil courts from hearing disputes under it. At the same time, it does not specify whether labor courts and tribunals can hear these disputes. Note that the Industrial Relations Code simplifies the dispute resolution mechanism such that the cases pending before labor courts will be transferred to tribunals. A full analysis of the code is linked in the description below. You can watch the rest of our videos to know more about the four labor codes.